someplace in Iowa where they actually blocked off the interstate, except up north of Highway 20 or 35. That's all you need to know right there.
So how long is your scholarship? 2 years, okay.
At least you know you're
We were looking at...
Good afternoon, everybody. Thank you for coming.
I'm Mark Bennett, retired federal judge as of March 2nd, and with the Drake Law School, the Institute for Justice Reform and Innovation. Wanted to welcome you all to the Des Moines Jury Improvement Lunch. Here's what the schedule is. We're going to have some remarks from Chief Judge John Jarvie. Then we're going to have some remarks from Steve Sussman, and I'll tell you a little bit about both of them. And then we're going to have a panel discussion with all of the judges in the room. If we missed any judges, please come on up and we'll find a seat for you. So I'm very pleased to introduce Chief Judge John Jarvie. I first met Judge Jarvie in 1981 when I was teaching my first trial advocacy class, and he was the star of the class. He's a graduate of the University of Akron in 1978, Drake Law School in 1981. He went on to clerk for Judge O'Brien, who then I succeeded in 1994 when Judge O'Brien took senior status. He went from the clerkship with Judge O'Brien to the Justice Department, where he was a trial lawyer in the criminal division, traveled all over the United States trying really big DOJ criminal cases. And then from 1987 to 2007, he was the magistrate judge, United States magistrate judge in Sioux City, and then he was elevated to United States District Court judge in 2007 in the Southern District, and became chief judge in 2015, although I bet it feels like about 5 years longer than that. And I had the privilege of having his son Matthew, who was a Drake Law School graduate, as a law clerk. And let me go ahead and, before we hear from Judge Jarvie, I'm just going to go ahead and introduce Steve Sussman. What an interesting character Steve Sussman is. He worked his way through Yale University, graduating magna cum laude, returned to his home state of Texas. He's from Houston, graduated #1 in his class at the University of Texas, was editor-in-chief of the Law Review, went on to clerk for Judge John Brown on the Fifth Circuit, and Judge Pratt knows about Judge Brown quite well, because Judge Pratt years ago told me about a book called Unlikely Heroes about the Southern judges on the Fifth Circuit who integrated the South. And of course, Judge Brown was one of those, and he actually entered an order in 1962 admitting James Meredith to the University of Mississippi. In 1980, Steve Sussman founded his law firm, Sussman and Godfrey, and also in that year, he kind of rose to national prominence. He won a very small verdict in a class action antitrust case. It was a mere $550 million in 1980 dollars. It would take a couple hours to go through all of his accomplishments. Well, he then clerked on the Supreme Court for Hugo Black. But one of the things that makes Steve Sussman so unique is he bleeds jury trials. He's such a true believer in the Seventh Amendment and a right to jury trials in civil cases. And he really pioneered alternative fee arrangements. And the philosophy that I think has driven Steve Sussman his entire professional life is he wanted to be paid for results, not for effort. Is that a fair statement? Yep. And he's also pioneered what's called trial by agreement, which I'm really into. And I required lawyers, when they filed civil lawsuits in the Northern District, the case was assigned to me, they had to read his law review on trial by agreement, go to the webpage, consult with their clients about using some of the procedures in trial by agreement, and then file an affidavit that they did that. He's here today in his capacity as executive director of the NYU Civil Jury Project. So please give Judge Jarvie, Chief Judge Jarvie, and Steve Sussman a very warm Iowa welcome.
There's two really good things about becoming a judge. First of all, for the first time in your life, your jokes become automatically funny. There you go. And And second, your law school revises completely your history there. And we just heard it again, star student, that's complete revision. In fact, Dean Calkins was my dean, and he claims he remembers me back then. Not true. But anyway, I do appreciate it. It is very nice to for you to invite me here today. Mr. Sussman, your project is just enormously important. It's a message that needs to go out and needs to keep going out. Oftentimes we hear about preserving the jury trial. Let's preserve the Sixth Amendment and the Fifth Amendment, or Sixth and Seventh Amendment rather, to the Constitution. Nicely preserve it. Unfortunately, it's preserved like some of the pharaohs are preserved. And so what we have to do is revive it, not just preserve it. One thing I thought about that we don't talk about much when we talk about the importance of the jury trial is the importance to not only, of course, the litigants, but the community as a whole. We're taught in the fourth grade that we're a government of the people, by the people, and for the people. And having spent years myself in Washington, D.C., and walking down those streets, you don't always feel like it. And of course, we all exercise, hopefully, our right to vote. But goodness, this government of the people, by the people, and for the people should be more than that. There should be more a tangible feeling about true self-government. And so when jurors come into my courtroom, they always come in the front door grumbling, which is fine. They all have something else that they need to do. Not all of them come in grumbling, but a lot of them do. They all have someplace else they need to be, and they leave as our salespeople, as our advocates for the jury system, because they become intimately aware instantly of the fact that it's not a king, a president, or a judge deciding their case, but rather people selected at random from the community. And in that way, they truly live out our United States Constitution and perhaps our most tangible form of, or tangible acknowledgement of true self-government. And so today, it's not about me, it's about this great discussion that we're going to have about jury trial. We need to talk about why we have a problem. It's very important, and what the solutions are, and I look forward to being a part of that mix. Mr. Sussman?
Thank you, Judge.
So 3 years ago, when I began this civil jury project at NYU Law School, it was and still is the only place in the country, academic center, that studies, ask the question, why are jury trials in this country, indeed all trials, disappearing? Do we really care? Is that a bad thing or a good thing? And if we care and it's a bad thing, what can be done about it? One of the first people I heard about and met back in 2015 when I began this was this judge, Mark Bennett, who was supposed to be some super champion of jury trials. And he is indeed. He's a resource you have here. Sorry I didn't get him to come to NYU and be my successor at the Civil Jury Project before they got him at the law school here. But he is fantastic, and so it's I come here walking in the footsteps of giants. The jury trial was so important to our founding fathers that it's the only right that's mentioned 5 times in our founding documents. The Declaration of Independence, Article 3 of the Constitution, and in 3 of the Bill of Rights. And if you just consider courthouses and courtrooms around the country, there's a jury box in every one of them. It's part of the architecture, the DNA of the American justice system. Unfortunately, those jury boxes are in disuse today. Well, this is a graph for the last 56 years that shows that the number of jury trials, which is the red line, has declined from an average of, this is federal only, declined an average nationwide from 10 per federal judgeship back in 1962 to last year, it was down to under 2 per average federal judgeship. And you see the blue line is what's happening to bench trials, which was really surprised to me. I thought, well, jury trials were being displaced by bench trials. I was wrong. That's not true. They are obviously both being displaced by private dispute resolution, if disputes are resolved at all. And so that's what's happening. And the fact that bench trials are going down so quick is, I think, a pretty good argument to say, well, you can't explain this by saying that jury trials are more expensive than bench trials, that they take longer than bench trials, that they produce a more uncertain result than bench trials, or that somehow juries are more susceptible to flamboyant advocacy than judges are in conducting bench trials. I mean, this has happened. And if you're going to ask why it's happened, you have to come up with reasons other than expense or time or some special competence in the decision maker. And for those, and the statistics in Iowa, as you can see, in 2018, there were 1.3 there were only 4 jury trials conducted in the Southern District of Iowa in 2018, civil jury trials, which is an average of 1.3 per authorized judgeship. There was, that's hard to believe the statistic, only 1 bench trial, but that's what the statistic shows. The Southern District of Iowa comes in 66th for the district court with the most jury trials per judge and 76 for the most bench trials per judge in 2018. Now, if you say, well, that's because these numbers are misleading, because the number of cases being filed in federal court are going down. But this next chart shows what happens. This accounts for that, because now we're talking about the percentage of cases that are disposed of by which are disposed of, what percentage of the cases disposed of are disposed of by either a bench trial or a jury trial, as opposed to a motion or a settlement or something else. And you can see for the same time period, the percentage of jury trials, cases disposed of, has gone from about 5.5%. Now it's less than 0.5% of the cases are disposed of by jury trials. The next one just shows civil cases resolved by any kind of trial, which is on a downward trend. And the final one shows that state cases in Iowa are not immune. You have the same pattern of jury trials. This is only jury trials are headed downward. And that's a bad sign. So let me talk briefly about what we have done at the Civil Jury Project over the last 3 years to try to ask the question, why is this happening and what should we do about it? I don't think anyone in this room feels particularly comfortable with those numbers. And believe it or not, the trial judges are people that are the most uncomfortable about being called trial judges, and yet many of them go on the bench, and for the first 2 or 3 years they're on the bench, they don't have any jury trials. So they're not happy with it, and when we recognized that, we immediately went out at the beginning of the project and tried to recruit federal and state judges across the country to become judicial advisors, meaning simply that they give us their email addresses, they will attend our programs, help us write articles, let us know when something interesting is going on in their court. We have almost 300 judicial advisors around the country. They're listed on our website, which is a site used by lawyers and judges. We also have 60 law professors who have done research or written in the area of jury trials, and approximately 40 jury consultant advisors who are also helping us with our projects. Our projects We do a lot of empirical research. To give you a few examples, one thing we discovered, again to our surprise, was that the majority of non-lawyers is totally unaware of those charts, of the trends in those charts. If you ask the average American non-lawyer whether the number of jury trials in the last decade has gone up or down or remained the same, 80% say it's gone up. So how does it happen, you might ask, that the public's perception of how busy our courts are is totally different than the reality when it comes to trying cases? And one of the things we need to do is correct that perception, because if the public is not aware of it, I mean, there's all the talk about judicial emergencies and how we need more judges and how there are too many vacancies and all this. You can go to any federal courthouse any day of the week in this country, and you can shoot a cannon down the hallway and not hit anyone. The lights in most of the courtrooms are dark. And a lot of state courts, certainly the ones in Houston, Texas, that I'm most familiar with, are the same way. The crowds that used to be there when I began trying cases 50 years ago are not there anymore. The courtrooms are not being used. Now, the judges are doing a lot of work. I don't take that away from them, but it's back in the chambers with their law clerks writing opinions or disposing of motions and not trying cases on the bench. We got some professors at Baylor Law School to look at all material business-to-business contracts filed by any public company with the SEC, which is required of public companies, with their 8Ks. If a public company enters into a material contract, they got to file it with the SEC as an exhibit with an 8K. We looked at 6,000 publicly available contracts to see how many of those contracts had jury waiver or mandatory arbitration clauses. And to our great surprise, only 43% did. So 57% of, if you translate the number of contracts to the number of companies, 57% of big businesses in this country want their disputes with other businesses to be tried in a public courtroom, either by a jury or by a judge, and not arbitrated, which was an idea that led us to another project. Was let's go interview the general counsel of those companies that have not inserted mandatory arbitration or jury waiver clauses in their contracts and see what they think. And we have gotten some incredible testimonials from those general counsel about arbitration has become too expensive. They don't want to go to arbitration. They prefer to have their disputes, except with consumers, obviously, adjudicated in public courtrooms. We have surveyed judges on their use of various innovations that we're going to be talking about today. We have tested whether some of those innovations actually work and make jury trials more reliable and more enjoyable. We have put around on programs like this around the country for lawyers and judges. This is our 28th jury improvement lunch. And so we have one scheduled day after tomorrow in Chicago. And we try to get jurors to attend, but we couldn't find any jurors willing to come to this lunch today. That's a sad commentary, I think, on the status, the healthiness of jury trials. It's very difficult to get them. In all of Chicago, we only got 8 to agree to come to our lunch, and they're all going on the panel. So it's not like you're any different than the rest of the country. It's hard to find people who have served on juries and been there till the verdict has been returned. One of the things we have done, we have hosted full-day workshops at NYU. We invite 30 state or federal judges at a time. We've had 150 come, 5 different workshops, a full-day workshop on how to try jury cases. We learned that the federal school for new judges, and I've been to the Federal Judicial Center and seen the program for new federal judges, they don't even have jury trials on the curriculum. Now, if a judge does not know how to try a jury case, when they get a close call on a summary judgment motion, what do you think they're going to do? Grant the summary judgment motion. It's easier. They go back. They don't embarrass themselves. So if the judges forget, and part of the things we're working on is how to train trial advocates, because if they're, it's hard to justify being a dinosaur hunter if there's nothing out there to hunt. And yet, trials will become extinct if they do not lawyers coming up that are able. One of our sponsors today is ABOTA. ABOTA can't get any new members who don't have gray hair, because one of the requirements in ABOTA is now that you must have tried 10 cases, first chair to verdict. Hello. There are very few lawyers anywhere in the country, young trial lawyers, who can meet that. So ABOTA's thinking about, we got to change our admission requirements. This has a ripple effect through our profession. In any event, we have 2 more workshops scheduled, one for April 23rd and one for May 10th in New York, and where we talk about care and feeding of juries, jury selection, jury comprehension, and last but not least, training of the trial advocate. For 2 years, we have published a monthly newsletter. If you came today, we have your email. You'll be on our mailing list for those letters. We have, in addition to this website, created another website called WeThePeopleWeTheJury.com. And what we do here is try to get people who have received a jury summons and are about to throw it away, and they are surfing the web to find out how you get out of jury duty. We want to send them to this site and they click on receipt of jury summons, and if you go on this site today, you will see these wonderful testimonials that we have accumulated, video clips, 2 or 3 minutes, from people who have served on juries and say, it's the best experience I've ever had. It's phenomenal. I mean, I'm sorry we did not have any people from your community, because when we have these luncheons and we have jurors show up, we take them aside with the video. All these lunches are videotaped. They're all on our website, 29 of them now. But the jurors tell the people who got in the summons, don't throw away your summons. You're about to have the best experience a person can have. You'll work with all kinds of people, et cetera, et cetera. And then on the other side, if they've served on jury duty before, we actually ask the judges to distribute to discharged jurors this business card, which all of you judges have been given as you walked in. As you discharge jurors, give them this card, which allows them to go to this website and blog, essentially fill out a questionnaire about how they liked it, what can be improved. We've had thousands of jurors go to this website. If you stay at a Holiday Inn, you fill out a satisfaction questionnaire. Why don't we ask jurors who are giving valuable time to do the same and share with us how we can improve the system? So this is, and we have a very active social media presence too, and by going to this, using social media, we try to get to those who have received a summons, who are going to Twitter and Facebook, trying to figure out a way to get out of serving. You should have at your tables, and also we put at your tables a one-page list of the reasons we have accumulated for the decline in jury trials. Take that list with you. It has an email address on it. If you have other ideas how the list should be improved, if you want to add something, tell us. We have tried to characterize the reasons for the decline. There are 18 of them, into things we can't do something about and into things we can do something about. tell us about that too, because right now we are not working on the things on the left side of the page. We are working on things on the right side of the page, those that we can do something about. And today our focus is going to be, how can we reduce the expense of trials? How can we improve not only the reliability of trials, jury trials in particular, but the public's perception of the reliability of those trials, so we can pick up some of those 47% of the companies that are waiving jury trials or insisting that disputes be arbitrated. And we've got to remember that that's what we're in competition with today, this alternate method of resolving disputes. There is no alternate way of exposing ordinary citizens to, as Judge Jarvie said, it's not just about the litigants, it's about exposing the ordinary citizen, the non-lawyer, to how the justice system works in this country, to how government works. It's the only chance in their lives they will get to serve as a government public official for 2 days or 2 weeks or even longer. And it's the only mandate they get in their lives that forces them to work with people from all walks of life. The whole spectrum of demography is there. People of different educational backgrounds, different racial backgrounds, different everything, all have to come together and listen to each other. And in a world where some question whether there are any facts, whether it's all alternative facts, it's important that we call these citizens together and say there is a truth, and you 12 people working together can find it. We talk about the Founding Fathers wanted juries because they were worried that judges who were appointed by the king would follow the mandates and wishes of the king. Boy, we live in pretty scary times now where judges, federal judges, are subjected to a litmus test. We have judges being appointed today who have never seen a trial to sit on the federal trial bench. That's no longer a requirement of being a federal district judge. And of course, 98% of disputes in this country are decided in state courts, where it's also important that trial experience and the jury, the right to trial by jury, be honored. When the Seventh Amendment was passed, the Constitution of every state that joined the Union guaranteed the right to civil jury trial. So all the Seventh Amendment had to do was preserve that right as it existed in common law in every one of the states. So this is nothing they dreamed up. It was what they were used to. Now I would like to, as we begin the program, and I want to show you a little film, if the judges who are here will come forward, we're going to have a panel discussion. And we want you to participate in that discussion by asking them questions. Raise your hand. Michael, do we have a mic out in the audience that you could pass to people? All right, well, you may have to pass one, but let's wait until the questions. In any event, I want you to, as everyone comes up, let's look at this.
Thank you for coming. Now, I realize that you were summoned to this class without signing up for it, and you haven't even been told what this class is about. Nevertheless, let me tell you what the rules and procedures are. This course could take a few days or a few weeks. I'm not sure. This course could be taught by 10 or 20 different teachers, and it will involve a subject you know nothing about. In fact, if you knew something about the subject to be taught, you couldn't take the class. Each teacher will give you relevant information about the subject, information you'll need for the final exam. However, I will not tell you what is important and what isn't. Not only must you determine what is consequential or not, you must also figure out which teachers have told you the truth. And you can't take notes to remind yourself of what you've heard or what you thought was important. Also, you may not ask your teachers any questions, no matter how confusing the lectures are. Nor are you allowed to talk to your fellow students about anything the teachers have said, even though this is normally how you go through a college course, or life for that matter. And while it might be helpful to have a notebook for notes, course materials, or even an idea of what the final exam might be about, it ain't gonna happen. However, we will let you look at some of the materials while one of the teachers is lecturing on another important aspect of the course. Now, I won't be telling you what is important in this course or what the rules are for the final exam until all the teachers have given their lectures. When I do explain the final exam, I'll spend only 15 or 20 minutes on it. And I will probably use unfamiliar or technical terms that I will not explain. The final will involve only 1 or 2 questions. And you will have 1 sheet of paper to write the answer on. You can then discuss the course with each other, but bear in mind, you will all have to agree on the same answer to receive credit for the course. You will also be locked in this room until you reach agreement. Oh, and one more thing. Depending on your answer, someone you don't even know will either win or lose. Any questions? Good. Let's begin. This will be a rewarding experience for all of us.
Okay. Now if the judges would come forward, we will. That film was done in 1998. It was done by the International Association of Defense Counsel. I think it was done to persuade someone that how can jury trials be relied on because we handicap the jurors so much. A number of the things in this film have been corrected. There's probably, except in New York State Court, no place in the country where jurors are not allowed to take notes. Almost every court I know of, they allow jurors to take notes. But we will now begin discussing some of the things. And let me begin by asking Judge Janet if you took a look at our list of the reasons why you want to add Indian.
I don't.
Do we characterize them right?
I think so.
Any of the other judges have any comments on our list of the reasons why trials is good? Well, it occurs to you during the course or during our afternoon Yes.
I think we created the fairest system in the world and no one can afford to use it. None of my plaintiffs, personal injury friends could bring a $30,000 or $40,000 case. They can't afford it. The folks, my friends that defend those cases can't afford to go through a jury trial. Their clients can't afford that. We've created this incredibly fair system, but it's so expensive that you can't afford to use it in many cases.
Let me ask you this question. I'm trying to figure out what spend time. Why was it less expensive in the late 60s than through the 70s?
Wasn't there, but I know the discovery costs are astronomical, and I think that's the chief evil here.
Well, and would you agree that the discovery costs are the same whether it's a
Yeah, I don't know, but my guess is that they
Would you agree that the biggest discovery cost today is electronically stored information?
in big cases, yes.
Because now almost all courts limit the number of depositions you can take. The number, is state court are in limits opposed, Judge Hubbard?
There's no limit, well, not in terms of depositions, no.
How about how long a deposition can last?
No, I mean, you executive order, you think it's going on too long, anticipate an issue, but nothing is done preemptively.
So you don't have a 7-hour limit or anything like that in the state court?
Not out of the block, no.
But federal court, they limit the depositions now.
Correct. Presumptive.
7 hours, right?
Correct.
So I think the biggest expense today is the production. It's not expensive to produce computer stored evidence. You do a word search and the computer can find any document, zillions of documents in a matter of seconds. Any document that hits on one of those search terms can be found. The expense is that the producing party is paying its lawyers to read and review every document for relevance and privilege before it's produced. Can we get agreement that that's the most expensive part of electronic discovery? And if that is the case, which I suspect it is, which causes lawyers to spend hundreds of thousands of hours in front of a computer screen reading these documents to make sure that they are relevant to the dispute and that they do not contain privileged information. That if we somehow change the rules to require that material be produced if it hit the search terms, regardless of whether it was relevant, unless the documents contained a lawyer's name. We're almost all talking today about emails. So, I mean, there are things that we could do. Change the rules of what must be produced. Because I think most of the expense of electronic discovery is self-imposed on the party that's being called. Having a computer should make it cheaper to get documents, not more expensive. Judge Bennett, what do you do?
Well, I think this notion that you really started of trial by agreement is really important to reducing cost and delay. Most lawyers think if it's good for your side, it's bad for the other side and vice versa, but there's a lot of win-win situations, and you've kind of identified that in trial by agreement. So I think that movement, trial by agreement, really has a lot of potential for reducing the cost. And the bottom line is, plaintiffs ask for way too much information, boilerplate requests on the plaintiff side asking for everything without taking the time to tailor the requests, and then the defense files boilerplate objections. And so if you got rid of all the boilerplate and just worked on what's really important, you could substantially reduce costs and delay, in my opinion. I'll just tell you this. So I did a lot of plaintiffs work and defense work too. I had an open file process. I would make anything available in my file to their side, including all of my work product and including attorney-client privilege, which I was more than willing to waive with a limited waiver in discovery because it convinced the other side, if I was on the plaintiff side, that I had a really good case, or on the defense side that I had a really good defense. So I think lawyers on both sides hide behind privilege and work product way too often when it's actually in your client's best interest to have a limited waiver and give that information up.
Judge Gamble, how would you cut the expense of discovery?
Well, I think one way to cut the expense of discovery is to limit the number of depositions and to limit the depositions to the witnesses that are really important. Recognizing that that the cost is to be borne by both parties. Plaintiffs bar and are preparing cases out of pocket on the come, and the defendants are often bearing the cost of production and paying their lawyers by the hour.
Judge Jarvie, what would you do? I think
it would depend on the size of the case, but let me give you a good example. Police excessive force case. When an excessive force incident, alleged incident happens on the street. There's 6 people there. And then when it comes time for the trial, there's 8 because there's an expert or 2. And so the identity of everybody is known on the night of the incident out on the street. Set that case for trial in 6 months and limit the depositions to 1 hour and try it 6 months later without very much discovery at all. There's so many of those run-of-the-mill kinds of cases, not the huge class actions and things like that, but the kinds of things that we do day in and day out that can be tried without almost any discovery. I'd have small claims court go to $200,000 if I had my way.
Well, let me ask, in preparing for this, I read that in Iowa, in the state system, there's some expedited procedure for 75, the amount of controversy is under 75,000. So they have one in Texas too, and no one uses it. Totally not used. They have one in California. Total failure. No one goes.
Right.
How about in Iowa?
Someone always perceives that it's in their advantage not to agree to it, but that's where the court has to get involved and impose it.
Right. It doesn't, the sensible thing there mean that we have to have rules that the judges either have to do it themselves and take control and eliminate, okay, or we have to have just rules that certain kind of cases are only going to last so many hours and so many depositions.
Well,
because the lawyers are not going to agree.
The thing about the Iowa rule, and Chief Judge Huppert and Judge Gamble know it far better than I, but the brilliance of the Iowa rule on expedited trials, which separates it from all the other states, I think there are 16 states that do it, is that the plaintiff can force the defendant into it by limiting their recovery to $75,000. The defense can't opt out of it, and there's very limited discovery, early trial date, and it really works. So,
one of the things that judges could do that we are urging them to do, and I'm curious what your reaction is first set the case for a definite trial date very, very early. I mean, at the first pretrial conference or the first status conference, case management conference, whatever you call that event, Rule 16 conference. You set it for trial then, you set it for a definite amount of time, and you tell the lawyers, one of you or I am going to have to die to get a continuance of this trial setting. So how about setting cases early, setting them for a definite amount of time, and making lawyers know there will be no continuance. Get ready. Do you do that, Judge?
We try to do that. That was always my predecessor, Chief Judge Gamble's mantra, and we've tried to continue that. Although conversely, holding lawyers' feet to the fire only just creates the timeline on which they're going to settle. I mean, normally it's the firm trial date that forces them to get the case resolved, and so it may have the impact of getting a trial date, but it doesn't do anything to preserve people's interest in making the decisions to take that case to trial rather than settle it.
Sure. So I think we got to think about, there are some things, one of the things we can't do anything about is the settlement. People want to settle cases. We know more today than we ever can about what the likely result's going to be, because we have jury consultants who are mock trying these cases. So you have a big case, both sides are using jury consultants and conducting a mock trial to predict what the outcome's going to be. We have free and open discovery. One of the professors at Yale, Langbein, said that one of the reasons trials are disappearing is it used to be the trial was used for discovery. Now, the pretrial rules, we have so much discovery that good lawyers don't need to go to trial to learn the facts. You know the facts before the trial begins, and you're able to settle a case. I think those are all good things. What is a bad thing is when you settle a case because the judge will never give you a trial date until all the dispositive motions are ruled on. There are no deadlines. Anytime a deadline is set, it is moved. So the lawyers have to go back and do it again. Those are the things we do have control over. So, yes, I think lawyers will settle the case. One of the things that we put on the left side is, the big picture, unfortunately, is since 1980, I think I'm right, and I'm subject to correction, there has been an effort in this country to reduce the amount of litigation. The word that most people associate with lawsuits is frivolous. Lawsuits are by definition frivolous. There's a litigation explosion. It's the tort reform movement, the lawsuit abuse movement has caused us all to think about, and all the legislation's called reform, securities law reform, antitrust reform, class action reform. It's all called tort reform, which really means we want fewer trials. We don't want so much litigation, because litigation's bad. And they have been very successful, working since 1980 for the last 40 years, in accomplishing those lines are their success story. They've been very successful. For example, caps on damages take away the appeal to the plaintiff's lawyers of going to trial. I mean, if I can get punitive damages or treble damages or enhanced damages, then, okay, I'm going to go to trial. Yes, Judge.
Steve, one of the things that I think we overlook is there's a wonderful book out by Prophet, Connecticut, called In Praise of Litigation. What the citizens don't understand that I think we do, that are lucky enough to be in the profession, is that a trial is the living out of democratic values. And so when we talk about frivolous lawsuits, the people that determine that ought to be, we leave that in the Seventh Amendment to jurors. So I think, resolving disputes is just the tip of what the court is supposed to be about. We're supposed to be the living, breathing part of democracy. One of our colleagues, who I think has a handle on this, Bill Wilson's a judge in eastern Arkansas, he says, the judge ought to be a verb as well as a noun. So when the lawyers are having a dispute, a deposition about answering, or even an interrogatory, he takes every call to his chambers. The judge has to be actively involved in this case if he or she is to get the case where you want it. And I think, sitting back and letting the lawyers be in charge of it, the reality is, you know this better than I, trying lawsuits is very hard work. Some people don't want to do it, okay? And the inertia that's come about by arbitration, mediation, and those things, we should keep in mind that, the root word of arbitration is arbitrary. And I just think that we judges have been laying down on the job by not being more active about controlling the way the cases get to trial.
So how do you explain every innovation that we are promoting? Let jurors ask questions, give instructions at the beginning of the case, give everyone a written copy of the instructions, give everyone a copy of the verdict form, let there be interim argument. Everything we are promoting has been suggested now before for 25 years. And yet the rate of adoption, and this is the surprising thing to me, I would have thought that federal judges, they don't have to be elected again. They don't have to make anyone happy. They have total independence. Why are federal judges so slow to adopt change? I mean, lawyers' participation in voir dire. We were basically shut out of the federal court, federal jury trials. We couldn't participate. That's just coming back now, that lawyers can even ask questions in jury selection. In state court, I assume you've always allowed lawyers to ask questions. So what is the explanation? I'd be curious to hear if anyone has an explanation why state judges who are subject to, many of them, election, stand for re-election, where they are, they are in many ways more innovative as I go around the country than federal judges. I don't understand that. Do you have an idea, Mark?
I've never understood it either, because I've used virtually every innovation you've talked about, and they all came out of state court, and they all came out of conversations I had with state court judges around the country at conferences. So, for example, I was always opposed to jurors asking questions because I thought it changed it from an adversary to inquisitorial. I was sitting at lunch with a group of Texas judges, and they told me they've been letting jurors ask questions of witnesses for years, and it's the best thing since sliced bread. So I tried it. It was great. But I don't know. Federal judges are very reluctant to change. I mean, one of my innovations that I started in 1994 is very simple. Jury instructions at the beginning of the trial, a complete final set with the table of contents. Okay, let's forget that you don't want to do the instructions at the beginning of the case. Fine. A table of contents isn't a better innovation than just listing instruction 1, 2, 3, and 4. How about introduction, burden of proof, plaintiff's claims, defendant's defenses? You put that at the table of contents. I couldn't get other judges to adopt that. It's clearly a better mousetrap from a juror's perspective. I don't know why that is. Judge Jarvie and Judge Pratt, do you know why judges are so slow to adopt better mousetraps? Maybe they don't see them as a better mousetrap.
I don't know. I think in our circuit it's a mixed bag. You know, we've had, Judge Lay for years discouraged, or was our chief judge for 11 years, he discouraged jury questions because he thought it interfered with the adversary system. On the other hand, moving from less than 12 jurors, people like that, even though, many judges I know will never do less than 12. We had Judge Arnold as our chief said, anything less than 12 is a committee, it's not a jury. So I think it's a mixed bag about whether or not people want to innovate or change. I don't know what judge.
Do you think, the state judges, do y'all stand for election here? Retention.
Yeah.
So do you think it may have something, what I've seen noticed going around the country, the state judges who stand for re-election, jurors are voters. They are more concerned about befriending the jurors, making life easy for the jurors, making it a wonderful experience than the federal judges. I don't know, I understand that, and maybe that's an explanation. Let's talk about questions. Which of you allow jurors to, as I understand, the practice is permissible in federal court, in civil cases for sure, and in this circuit. And it is permissible in state court too, here. So which of you allow jurors to submit questions to the judge? All right. But none of the states, 3 of the state judges don't do it? Why? Judge Lava?
I've allowed it once. I've done it once. Didn't get any questions.
Well, now, did you make it well known to the jurors that they had the right to do it, that they would be?
We talked about it in my introductory comments about the timeline for the trial, and set out the mechanism as far as getting them. They'd be screened by the judge and the lawyers and all that.
Judge Lauber, how about you?
I've never done it. I've never had any lawyers ask to do it. I know that sometimes they will file motions ahead of time asking for that. I've never had anyone present that to me. As a lawyer, I had a case in front of Judge Gritzner where we allowed jury questions, and so I've done it as a lawyer, but not as a judge.
Let me also suggest to judges that we will never make innovations if you wait on the lawyers to suggest things to you. Okay? They're not going to do it. The lawyers, they're too happy making the money that they're making, billing by the hour to do it the old way it's been done. And I don't think the lawyers, that's why I think innovations, this jury project that we are doing right now is the first one in the country that has begun with the judges. We got to get the judges to be the innovators. Because if it doesn't begin with the judges, the American Board of Trial Advocates are not going to introduce anything. The American College of Trial Lawyers, they talk about committees and things, but they're really, they always have to satisfy both sides of the docket, and there's always some reason if I suggest to another lawyer, let's encourage the judge, let's go to the judge hand in hand. That's what these trial agreements are, to go to the judge before the trial begins and say, let the jury ask questions, ask the judge to give substantive instructions at the beginning of the case. And I don't mean by just who has the burden of proof and how you judge credibility, but here's what you have to prove fraud, and here's how you measure damages, and here are the 5 questions you're going to be asked on the verdict form. Here is the verdict form. This is what you can take notes on it. And here's a written copy of the instructions. That, the lawyers are never going to do that. I can never get lawyers on the other side really to agree to that, Judge. I mean, they always think that if Sussman is asking for it, it's got to be good for him and bad for me, which is a horrible way that we have in the adversary system gotten. I mean, there are things that with all the lawyers in my firm, I have a hard time getting them out of that thought pattern and that they're in. Yes?
Very early in my career, maybe my second or third year, I had an elderly juror in the front row raise her hand, and she said, why does everybody have water to drink and we don't have any? And I said, that's really a great question. I said, you're not going to like the answer because it's always been done that way, but you know what, we're going to change that. And I did change it, eventually got cup holders put in the jury box. But that got me thinking about framing the question. So my entire judicial career, I tried to look at it, what would I want if I were a juror? And I think judges don't really look at it that way. And I think if you start looking at what would you want if you were a juror, all of these innovations and plus others that you'll think of make a lot of sense.
Judge Pratt.
Steve, one of the things that I think your project, which is wonderful, overlooks is the impact that jurors have post-jury service. The studies that have been done tell us that people who have actually served, as opposed to being called or in the pool, actually become much more involved in their communities, the other 2 branches of government, the legislative, the executive branches. So from a public interest standpoint, I think saving the jury trial has a more broader focus than just saving it for litigants. We need to save it for the public interest.
Yeah, I would point out, Judge Pratt, that the only thing I've ever read, I've looked for studies like that, and I've tried to figure out how we could do an empirical study. The question is, does serving on a civil jury that actually deliberates and return a verdict make a person a better citizen? The only way that's been measured is checking whether they vote, the voting records, because you can check that. And there has been a correlation between a person who serves on a civil jury that returns a verdict is more likely to vote than someone who has not served on a civil jury. But I haven't found any other way, and I'd love to find another way of testing. Does it really improve citizenship? So, I mean, it's certainly, it's helpful, I think, for us as lawyers and judges, to have a public that knows what's going on in the courthouse. I'm mystified, totally mystified with the judges, including our Supreme Court, that disallows cameras in the courtroom. I can't figure it out, why it's done. What's going on there that's so secret? Why don't we open our courtrooms to this fresh air and let people sit at home and watch trials if they want to? So let me ask another question. Do any of you, like is Judge Bennett the only one who gives the final instructions at the start? Judge Jarvie, you do?
In non-complex cases. A felon in possession of a firearm will give all of them out front. Depending on the complexity of the case, I'll split them up.
So let's say it's okay. I would think that the jury would need more help in a more complex case, not less help. So how does that make sense?
My theory is that at that moment they're starved for the facts,
and the minutia of, for example, a regulation as to how, under the Federal Election Commission, how a payment could be categorized. It's a little too much law for them at the beginning. So I'd certainly give them I'd give them a copy of the indictment. I'd give them all the elements ahead of time, but some of the definitions I'll leave out. So I'd give them an outline at the beginning and then more of the minutia at the end in a complex case.
Will you give them each a copy of the verdict form?
Absolutely. Yes.
Each juror gets one?
Yes.
At the end?
Every single time at the beginning.
At the beginning?
Yeah,
they get the jury?
Every single time.
Verdict form. That's great.
And if it's a complex indictment like a mortgage fraud where there's 6 different properties and 3 different dates and all the different dollar amounts, I'll give them a chart of that at the beginning too, so they can follow along.
One of the things that makes me mad is, which we can do something about, I think, is when you're forced to go to mediation. Mediation's good. I like mediation. Lawyers should have to mediate, spend a day in mediation before they take a jury's and a judge's time trying a case. But I don't think it's fair to make us mediate cases before you resolve the substantive motions. I think the judges ought to you ought to do your work, resolve the substantive motions, and give me an actual trial setting. So I am not forced to settle the case because I look at my client and say, to tell you the truth, I have no idea when Judge Jarvie's going to set this for trial. He might be dead when he gets set for trial because they're retired or something else. These judges do leave and you get a new judge. I may be very happy with him, but all of a sudden I get a new judge. It seems to me, and then you have these mediators telling you, oh, you need to settle this case because going to a jury trial is like a crapshoot. It's like going to Las Vegas, betting on a rule with let. Now these are, when they were wearing their judges' robes, they said, you can trust a jury. They get the right result. I can even predict what the result is in many cases. The jury consultants are telling us if they do the research correct, they can predict the result in cases. So, but the pressure now to settle in mediation is intense because you don't have a trial setting, you don't have a ruling on motions that could affect the result, and you have a mediator who was wearing a robe last week as a judge telling you, you don't want to go to a jury trial. You need to settle this case right now. That's a lot of pressure. And I suspect it's, more pressure. Because one of the things we have to do in figuring out what role everything plays is what was going on in the 70s when those numbers were 10 cases per judge or 8 cases per judge. What was going on then it's going on now that wasn't going on then that causes this decline in the number of trials. Do each of you ask, after the jury serves, do you give them an opinion poll, some feedback form? Are you doing that, Judge Bennett?
Yeah, I've always met with the jurors for 24 years after the verdict, debriefed them, answered any question I could answer, and then implored each of them to talk when they go back into their communities, to talk to at least 5 people if they had a good experience, which I'm almost positive they always did, to be an ambassador for our court. I think that's really important. I think Judge Pratt touched on that, and Judge Pratt has done a lot to elevate the role of jurors. He has jurors at a baseball game. And Bob, why don't you talk about some of the things you've done?
All I did was when I started, I plagiarized Judge Bennett's form. So I used the same form that he used to get feedback because I tell them, I give them a thank you letter when they come back. And I tell them they don't have to fill it out, but I'd appreciate it if they would, because that way I think you get more honest feedback about how you did in doing your job. But then I go on to, I talk to them as well. And then I've done a little bit of juror sentiment in sentencing, along with a couple of other judges, one from Northern Illinois and another from Ohio, because they want to know what happens in a criminal case. They want to know what the sentence is going to be. So I've always told them that I'll keep them in mind. So, but that's the wonderful part of the job. So.
Can you talk about your Juror Appreciation Day that you've done?
Yeah, well, I've done a Juror Appreciation Day along with Chief Judge Gamble. Art has helped me out as well because I think for the most part, there's very little thank you about what they do. And the wonderful thing about what we get to do in talking to them is, you know you've done a good job when you've had someone at the beginning who's reluctant to serve, and then somewhere during the trial, this only happens in a criminal case because we don't have alternate jurors in civil cases, but if they will tell your law clerk or the courtroom deputy, I sure hope I'm not an alternate in this case. You know, that tells me that they like what has gone on. So.
Let me ask you, Judge Pratt. You get a summary judgment motion. First place, do you have any screening device where lawyers have got to get permission to file a dispositive motion? Like write you a letter?
No.
They can file it?
Yeah, they can file. Yeah, there's no, yeah.
At any time they want to?
Yeah.
Can they file multiple summary judgment motions?
Multiple?
Yeah. Seriatim.
I suppose.
Multiple bites at the apple. You don't control that?
No.
No wonder it's expensive. I mean, that gets expensive.
Yes.
Why don't you do something that, I mean, I've had judges that say it's a lot cheaper and quicker and better for me to tell the lawyers, we're going to have each of you gets a day to try this case, and the trial begins next Monday, than to go back and have to review 8 inches of summary judgment submission and write an opinion. So what do we do about that? What can we do to encourage judges to actually make the parties go to trial? Anything?
Make the parties go to trial. I mediated 400 to 500 cases as a magistrate judge, and by the way, I never told them, I never tried to scare them out of a jury trial, not one single time. But in 400 to 500, I only saw 4 or 5 plaintiffs who really wanted a trial. If they don't want one, why are we, as you said, trying to make them have one?
Well, do you think that they don't want them because the lawyers don't know how to do it? I mean, I've had judges say that.
They're afraid to walk in the front door. They don't want and they don't want the delay, and they want certainty. That was my experience.
Because
I think to get more trials, we make it less expensive so that more people are in the system.
Something is happening because the uncertainty was no greater today than it was in the 60s or 70s.
Yeah,
right?
but in the 60s or 70s, and I wasn't there. I was there, but I wasn't a lawyer. But in the 60s and 70s, it was people trying automobile accidents left and right, and the insurance companies came to the conclusion that if you put a good submission together ahead of time, you don't even have to file this case.
Okay.
And they started to recognize that they could resolve these disputes without you filing. In the 60s and 70s, wasn't that the mainstay of the trial lawyer's business is automobile accidents?
It was.
I think that's what happened there.
That did happen, and that may be a big, I know when I began trying cases at the end of the 60s, the 3 largest law firms in the world were located in Houston, Texas. Vincent Elkins, Fulbright, Jaworski, and Baker Botts. They are tiny. They're boutiques compared to the other firms today. And they were large then because they all had at least 100 lawyers trying insurance defense cases. That's disappeared.
Steve, one of the things that Judge Jarvie just raised with you gets me back. I think we've talked about this before, and I know Judge Bennett and I have. Judge Hornby, who's the opposite of Judge Young in this, we need more jury trials, the trial judges, are the problem. Judge Hornby claims that these decisions about go to trial, not to go to trial, are essentially made by clients, not by lawyers. I've got one of my colleagues on the district court came from what for Des Moines is a large law firm, and he tells me frequently, well, you got to understand, Bob, businesses want to know the quote-unquote bottom line. If they can resolve a case with certainty. I mean, I don't know if this is true. I was never in that kind of law firm. But I think, Judge Young does say that the business community has lost faith in the jury system. Do you believe that?
No, I don't believe that, because I've talked to too many people in the business community. They like the jury system. They like to have a judge that can set aside a runaway verdict. They like to have an appellate court that can set aside a runaway judge. They want mandatory arbitration in contracts of adhesion to avoid aggregate litigation. It's all about avoiding a class action, okay? That's what it's all about. It's not that they love arbitration better than trial in a courtroom. It's that they know that if they peel off one individual at a time with a $2,000 claim, and don't let them aggregate in a class action. So I think there's a great deal of faith on the part of the business community. And the judges in Harris County, the state court judges now tell me, the insurance companies love jury trials. In a medical mal case, they much prefer a jury return a verdict than have a bench trial, because they know that jurors have been conditioned to think the people who filed a lawsuit are malingerers, that they're no good at all. And alas, the insurance company that insures lawyers from legal malpractice claims insisted that we remove from our fee agreement a mandatory arbitration clause. They wanted a jury. They're going to have to pay the bill, and they've studied it enough so they think that lawyers are going to get a fair shake in a jury trial than from arbitrators. So, I think there's a trend back to the wisdom of 12 people in this country. So I don't know about that.
Well, why don't we ask Judge Cupper, if he came from a well-known business law firm, tried a lot of cases. Mike, did you find that the business community has both confidence in the jury system? Did they distrust it? Do they distrust the jury system?
No, I think the perception, probably the reality, is that in the business community, they do look at the bottom line and a certain result, and the benefit that we have in Iowa is that we have a judiciary and a court system that provides the vehicle to get to that. Now, I can't speak to the decisions that are made within the business community to try to skirt the court system by way of arbitration or whatever, but in general, cases get resolved, and I think this is whether it's a business litigation or a personal injury case or anything else, on just basic principles of risk-benefit of going to trial. And I don't know whether these innovations we're talking about are going to assist in that. If they're really two different paths as I see it. But there is a reason why the civil litigation system is being bypassed through arbitration and ADR. But some of it is, in large part, is because cases that are being filed are being resolved because either the cost is too great to get to trial and a verdict, or they just make the decision that I'm going to be in charge of our result and get it mediated or maybe arbitrated, but some kind of private resolution. So I think the business community is in favor of a strong jury system that provides for the kind of full-blown exposition of ideas and evidence that we aspire to.
Yeah, I think you're right. Let me turn to the audience now before we totally run out of time. We're almost, any questions you have of this panel? Anyone have any questions of the panel we have today? Well, let me ask one final question. I'm sorry. Stand up.
My name is Steve Beckley. I'm a litigator here in Moines. So frequently what happens with my clients, thank you, is as we approach trial, the expense of getting ready has already been incurred. They incurred that because they needed to find out what the evidence was before they could make a business decision, or even if it's an individual, before that individual could make a decision about whether to go to trial or not. But then they end up avoiding trial because they get scared of the all or nothing outcome. And so I'm wondering if there isn't some way to say to the parties, why don't you agree beforehand that the recovery is going to be at least this much and at most that much. And if the judges would encourage the parties to reach an agreement on those two numbers, that takes out some of that risk. They may still end up settling the case, but at least they can go to trial knowing that it's not going to be a worst case scenario or an all or nothing situation.
Good.
I don't know if that's ever been considered.
Anything else? Well, that's something someone has suggested that we ought to study the use in courts of high-low agreements that cabin the risk that, which is usually why people like arbitration, is that you're going to get something, kind of split the baby down the middle and not some extreme result. But to some extent, the extreme results aren't happening in this country today at all. All the studies reveal that the number of exemplary damage awards that survives, like in all of the United States last year, probably is no more than 10. Every trial. I mean, it doesn't happen very much anymore. Have you had exemplary punitive damages awarded by the jury in a case? So let me ask this final question. Training, because we have a lot of young lawyers here who I assume came because they may be thinking about being trial lawyers. What can the bench do to encourage young lawyers, encourage us to give, like one of the things we suggest is some judges have these young lawyer rules, where if you tell the judge, a young lawyer is going to argue a motion, I'll give you a hearing because I want young lawyers to have experience. Or they're more explicit about it. They have two lawyers in court and they say, Sussman, sit down. And frequently it's a her, let her stand up. And it increases diversity for judges to be very active and proactive in helping train advocates. Because if we don't train them, and so, Judge Pratt, what can be done more?
One of the problems that has happened is when I was a young lawyer, and I know, Henry Rothblatt came here, he was representing the Watergate burglars. He said, young man, the state of Iowa and the federal government have an obligation to teach you how to try a lawsuit. Get on those appointment lists, use your imagination, go to verdict. Well, now we got state defenders, we got public defenders. I got to try cases to verdict in both state and federal court, criminal cases. They were overwhelming. I lost, but it taught me how to try a lawsuit and behave. And so I think eliminating those requires us to do some things that we should do. We should have a second chair program in state and federal court that, we bring young lawyers along. The appointment process in our district with 1983, I think, has been helpful. Other than that, I don't know. It's up to the law firms to help us, I guess.
Judge Jarvie, do you publicize on your website the availability of trial-ready pro se cases? In other words, pro se cases that are on the docket of one of your judges that have survived a summary judgment, a dispositive motion, and are trial ready, but they're pro se cases. If I'm a young lawyer in this community and I'd like to take some of those cases, or I have a law firm and I have a bunch of young lawyers who want to be trial lawyers, how do I find out about them?
We make that decision earlier on in the case as to whether it merits, it requires the assistance of counsel. If it's a bench trial, we're less likely to do it. Our magistrate judges largely handle that. But to your point, what we can do, by the way, this Friday, I'm having oral argument in a case because somebody said, not because I published a rule, because they said we will have argument by a lawyer with less than 4 years experience, and I just instantly said it. Just a couple months ago, my son, who's a lawyer in Phoenix, got appointed by the federal district court to try a jury trial under the exact same thing that you said. And his firm was hesitant to let him do it simply because this pro se litigant is so litigious. And then the judge backed up the firm by saying this: you can't do any additional discovery. You will try this case as is, so that there could never be a claim that the firm
malpractice.
Yeah, and that was a really interesting thing that they did, and they really put them in a box, a narrow box. You're going to try this case, and it was a real smart thing for them.
That's great. Thank you. First, let me thank the judges for coming today, and we learned a lot. Thank you for coming, because I think one of the ways to preserve jury trials in civil cases is to talk about it at programs like this. If we stop talking about it, they will become extinct. Thank you for coming. Thank you, judges. Thank you. Thank you, Judge. It was great, Judge Hubbard. Nice meeting you. Thank you for coming.
Thank you.
Thank you.
Very well done.
Thank you for coming.
Yeah, all those